So we'll continue with the remaining school. Okay, so positivist we have seen. Positivist is mainly focusing on what is it? Do you remember? Positivist school or analytical school?
Positive school is like laws are written in legislation and need to be followed. And if not followed, punishment would be issued for that.
Yes. So,
And there are the jurists which suppose that, like,
Hmm.
what's the name? I forgot. John Austin, this guy was the main head of this positive school.
Yes. So analytical school, we focus on human-made laws. Laws are meant to be followed. If not, there is punishment as well for it. We need to face the consequences.
Analytical school and positive school both are same, right?
Yeah, same only.
Okay.
Okay, so here I have mentioned the names also. All these are same school only. What about historical?
Law is originated from history, and the law keeps changing by the nature of change in environment. This is what history.
So it's nothing but history and what we have faced, what problems we have faced, our customs, traditions, all those things influence it. And that's the reason why we cannot have one universal law, because our history would be different from that of another country's history. So law is like language. As you go out of a certain maybe community or a society, law needs to change. We cannot have one universal law. So also law grows and develops with people, like you mentioned, that with whatever is required, we need to bring changes as well.
Okay.
So law is found and not made. We have as such not like what analytical school said that law is like made. We cannot make the laws because it will develop with time. Whatever is the requirement, based on that only law will originate. So all custom, people, their needs, our past history, all of it influence what laws we will have.
Okay.
Okay, so positivist, human-made laws. Then we had this one, historical, based on our history, laws have developed. Next one we have is philosophical school or natural law school. Now, when we talk about philosophy, it's like something very much, like idealistic, right? Something which actually, like not like very much.
Of people.
Yes. Right. So when we talk about philosophical school, its view is also something similar only. When we say, okay, legislature is making the laws or it is developed from our history, it's something which we can actually practically feel. But when we talk about natural law school, it says that it has originated from nature or it is having like a divine origin, which looks very much philosophical. Okay, so what natural law school had to say? They say that law is based on reason. As in, law is based on reasoning. We have this inherent tendency within us whereby we are able to differentiate, right? Even though we do not have laws. Like you are studying law now itself, right? But even before that, you knew what is right and what is wrong, right? Even though you have not studied Indian Penal Code, you know that murder is a crime, or you know that causing harm to somebody is wrong, right? So it's nothing but this reasoning ability which we have inherently. Okay, so law is based on that reason only, which is some sort of higher principle that is just fair and reasonable. What is right, what is wrong, we are able to differentiate between it, and that's how law has originated. Law against reason or natural law are not valid. So if it happens that something goes against reasoning, then it would be something which is not valid. Okay.
For example?
Yeah, I'll tell you. See, take for example, when we talk about analytical school, what analytical school said is that it is about maximum happiness to maximum number of people. So if there is a law and that law is making maximum number of people happy, then that law is good. If maximum number of people are not happy, that means law is bad, right? That was the viewpoint here. Now, if you take this example in today's time, like we have reservation for minorities, right? So when we say minority, like minority in terms of number of people, okay, maybe it is a minority group like SC/ST, they are being given reservation. All right, now when government introduces a certain legislation providing reservation to a minority group, other people would feel like, okay, minorities are getting some benefit, they are getting reservation and we are not getting, right? Who will be happy over there? Obviously only the minority is going to be happy that, okay, we are getting some government support, we are getting reservation, right? But there is a majority who is not going to be happy with that because they are not getting any benefit, right? So in such a case, we would say that that reservation law is bad because it is making maximum number of people unhappy. But is that justified? Because reservation is needed for their benefit, for their upliftment. But if we follow this principle, what happens is that law will not be justified, right? Got my point, right?
Yes, ma'am.
So maximum number of people should be happy based on this, but that is practically not possible, right? Because if we are giving something to minorities, only minorities are going to be happy and majority would be unhappy. So in that ways, that law is not valid. So this is not correct, right? So in on that line, natural law school is something what it advocates, right? What it says that it is based on reason. It says whatever is proper, whatever is based on reason, that is good law. But if law is against reason or natural law, it is bad. So if we consider that, why are you giving reservation to minorities? Why are you giving reservation to SC/ST? SC's reason is that they have suffered a lot. There was a lot of discrimination that they had to undergo for all the past years. In order to justify that, in order to bring them to the same position, we are bringing laws. Okay. Okay. So that is nothing but what it is, right? That its reason is there. Why are you giving reservation? We're not giving it just like that, but there is a valid reason for it, that we need to bring them to the same level. They need some support from the government. So that's why we are doing. So in natural law school, that law would be justified. But if you talk about this other one, there it's not justified, right? So different laws, when you consider these different theories, will have importance. Okay, so under this natural law school, that law will be justified because it is based on reason, or it is having like a valid ground or a reasoning why that law is there. Law should be based on ethical values so that people are motivated to do something good for harmony of the society. And purpose of law is justice, and we need to know how law achieve justice. So main purpose is that good should prevail, justice should prevail, and that's how we behave, or we should behave. So natural law is the philosophy which believes that laws are not because of any legislation, or not because it's binding, or there is, like you mentioned, there is sanction, right? If we do not follow the laws, we will face punishment or consequences. That's why we follow it. So according to natural law school, it's not like that. We as such don't require a written legislation. We don't require the king or the courts to punish us, but this is something which is inherent. Okay, however, they are born out of nature. It has originated from the nature, because we have an inherent tendency to differentiate between right and wrong. Even though there is no legislation, even though there is nobody to impose punishments on us, we still are in a position to differentiate between right and wrong. We are able to know what is good, what is bad. So natural law is not taught to human. Nobody has taught us. Like how the other schools believe that, okay, it's command of the sovereign. If we do not follow, we will face punishment. It's not like that, but it is because of this inherent tendency which we have. It's not something which we are being taught, but it's something that we have within us. Natural law proposes that laws are a logical progression from morals. Like we say, right, this is morally wrong or this is morally right. So because we have this idea of morality, from there only laws have also gradually progressed. Therefore, actions that are considered to be morally wrong will go against the law. So whatever is morally incorrect, that is something which is not law as per natural law school. Also, actions that are considered to be morally right cannot truly and justly be against the law. Whatever is morally correct, that is something what like goes in favor of the laws. Natural law exists regardless of what laws are enacted. So it does not matter what laws are enacted and all, we have this inherent tendency, so natural law will prevail anyways. It has been given different meaning at different points in time. When we look at the history at different points, natural law was given different meanings, or how it has originated, why it has originated. It was given different explanations for that. Okay, so when we talk about natural law at different stages, it can be studied in 4 different stages. Okay, so first is the ancient theories, then we have medieval theories, then we have Renaissance theories, and then modern theories. How natural law originated at all these different stages, we need to know that. Okay, now first of all, talking about ancient theories, we have Greece and Rome, okay, how it developed. I'll try to prepare a table for this, okay, like a chart sort of a thing for you, because it's again divided in 4 periods, and then there are thinkers as well, so that will make it easier for you. For now, you can try to understand what these 4 classes are. In ancient theories, we have Greece. Now, the Greek thinkers developed the idea of natural law and they laid down its essential features. It started from there only. At that time, Greece, at that time, there was political instability that prevailed in Greece. And it was thought by many that law is made only to serve interest of the strong. But the same situation made some other jurists think in the other way. So some people thought that whatever laws we have, these are for benefit of the stronger people only. It's benefit for the ruling class only, and not for common benefit, not for benefit of the common people. But at that same point, there were some other thinkers who saw there is an opportunity to develop new universal principles that would address this problem, or that would address this instability that was prevailing in Greece at that moment. Okay, the arbitrariness that was exercised by the ruling class, they wanted to address it. Now, there is Socrates and Aristotle and their views on natural law, which we study in ancient period. Okay, so what Socrates viewed is that Socrates believed that man has his own insight, which makes him know of things whether they are good or bad. So we have this inherent tendency of knowing good or bad, and accordingly only we can inculcate moral values also. Because we know what is right, what is wrong, we are in a position to inculcate moral values within us. We are able to do whatever is good. So though through his theory, Socrates wanted to ensure peace and stability in the region, which was very much needed at that point in time in Greece. So if we are doing what is good, then we would not disturb stability of the state, or we would not disturb other people, right? So that's how he wanted to maintain stability or bring peace, which was very much required at that point in time. Okay, so what he believed is man has his own insight. They are able to differentiate between good or bad. Even though we have laws, we don't have laws, does not matter. Then we have Aristotle. Aristotle's concept of natural law is different from what Socrates had to say. Socrates said that we have inherent tendency of knowing good and bad. But Aristotle divided life of men in 2 parts. Firstly, he says that man is the creature which is created by God. And secondly, he possesses the quality of reason by which he can develop his own will. So we have this reasoning ability. Based on reasoning ability, by making use of it, we can develop our own will. It is this reason through which one can discover the principle of natural justice. Aristotle is considered to be the founding father of natural law school, and he gave this theory a valid, a solid ground that could develop naturally. So he said that we are created by God and we have this ability, right? Quality of reason is there within us, and based on that we can decide what we should do and what we should not do, right? Like developing his own will, we know what should be done. So in ancient theories we have Greece and Rome. Okay, when we talk about Rome, Stoics' views on natural law. So he was again inspired by Aristotle's theory, and based on Aristotle's theory, he made some changes there, and he made his own theory. Some key changes and made it more ethical. According to him, the world is governed by reason. Man's reason is also part of this world. Therefore, when he lives according to reason, he lives in accordance with nature and lives naturally. One of the duties of men is to obey the law of nature, as according to Stoics, law of nature is binding on everyone, and positive law must conform with the natural law. So yes, there might be some written rules, some legislations which may come eventually, but those need to be in conformity with the natural law. So what is natural law? It is something which governs the world altogether, and we are also part of that only, right? Entire world is governed by this reasoning, and we are also part of that world. Okay, so we are also following this rules of nature. And even when we talk about positive law, when we talk about written or man-made laws, those also should be in conformity with the natural law only. So what was his influence of his theory? There was a great influence of his theory on the jurists, and they started paying more attention to natural law. Natural law helped Roman people to transform their rigid lives into a cosmopolitan one. Sometimes the Roman courts also applied the principle of natural law in order to deal with cases that involve foreign people. In this way, natural law helped in development of Roman law also. So Roman law is considered to be having great influence in other countries' laws as well, right? So there again, we have seen this concept of natural law being applied, right? So it is something, sometimes you would see, even though you have written laws, written rules, judges do get an opportunity of playing an important role in deciding some cases. So in such cases also, judges should try to apply natural law only, what is right in a given situation. Based on that, they would try to give decision. Okay, so this is the first phase we have under natural law, which is nothing but ancient theory. In ancient times, what we thought about natural law, how it has developed. Then talking about medieval theories, we have Thomas Aquinas. He defined law as the obedience of reason for common good made by him who has the care of community and promulgated. So it is something which for common good we should follow, right? For benefit of majority, we should follow these rules or these regulations. He divided law into 4 stages: law of God, natural law, divine law, and human laws. Natural law is the part which reveals itself in the natural reason that is applied by human beings to govern their affairs and relations. According to Aquinas, positive law must conform with natural law. Even though you are having some written rules or legislations, it should not go against the natural law. Positive law will be valid to the extent to which it is compatible with natural law. So it should be in conformity with the natural laws, and its validity will remain only till the point it is compatible with the natural law. If it says something else, then in such cases it's valid. That law would not even be valid. That positive law would not even be valid, which is nothing but like man-made laws.
This medieval era is like not pure natural law, it ma'am. In pure natural law, it's like no punishment is there, something like that.
Yeah, so in that, at this stage, they are like, yes, you can have positive laws, you can have rules, regulations, etc., but then it should be in conformity with the with these rules again. Okay, so initially it was like from divine origin it has come, people only will be governed, people only will like behave properly. As such, we don't need sanction or something. But here it's like, even though you are having some written codes, written rules, it should be in conformity with the natural law only.
This happened
Otherwise,
in medieval era.
yeah.
Okay, ma'am.
Otherwise, it would not even be considered as valid. So Thomas Aquinas perfectly blended Aristotle's theory with that of Christian faith and uh, built a very elastic and logical theory of natural law. He pleaded for establishment of authority of the church over the state. According to him, even the sovereign has limited powers. It's not like they are having unlimited power. He identified natural law with reason, gave sanctity to the social and political organization, and pleaded hard for preserving social stability. Catholic modern jurists have built upon the theory of Aquinas, but have modified his theory according to changing needs and circumstances. So he did give importance to this political order or social and political organization. He did give importance to it. He said that church would have control over the state, right? So it is nothing but again giving importance to rules or laws which are having sort of divine origin, right? So he gave that concept in the medieval period. Next is Renaissance period. So during this time, there were a lot of or a huge change in terms of new ideas coming in, new branches of knowledge being developed, and new theories, new scientific concepts being developed. And during that time, there were a lot of developments happening in the field of commerce as well. So because a lot of new things were happening, we needed laws for protection of the state as well, because there were so many different areas to address it. We needed laws, and it gave birth to the concept of nationalism. All these factors together overthrew the dominance of church. New theories supporting the sovereignty of the state started coming up. The reason was the foundation stone of all these theories. Natural law theories of this age also have some characteristics. This theory precedes with the belief that a social contract is the basis of society. So at this point in time, church was given importance, right? That they are having some control, but at this point in time, it changed. But rather, sovereignty was given importance, right? Sovereign was given importance, and all these different areas that were evolving, we needed laws to regulate it. Okay, so after this stage came the theory of social contract. Okay, so what is social contract theory? Again, there are three jurists or three philosophers we have who developed this theory. Okay, so what is social contract theory? It again talks about a state of nature. Okay, all these three philosophers tell us what kind of a state used to prevail and what was the nature of that state. They mentioned about that. Okay, so state of nature is a condition which prevailed before a contract has been entered into. So there was a contract that people entered into, and before entering into the contract, what was the situation that prevailed in the society? There are three viewpoints of these three different jurists on that. Okay, so three philosophers gave different viewpoints on what sort of a society used to prevail before this social contract. We entered into a social contract. Okay, so what is a contract?
Normal contract is like a mutual understanding between two people on the
Yes.
same thing.
Correct. So just like how normal contract, there is mutually we decide the terms and conditions, and then mutually we agree to do something, right? Same ways it is a social contract, as in terms of the society, people enter into a contract. Okay, people enter into a contract amongst themselves to make their lives better. And regarding that, we have these three different jurists giving three different viewpoints. All right, you can remember names of these three jurists in this order only: Thomas Hobbes, John Locke, J.J. Russo. All right, because they said that society was very bad, brutal, nasty before we entered into contract. Okay, John
Ma'am,
Locke
can
said that,
you just
yeah,
simplify this social contract thing definition?
social contract, you want to know what it is exactly.
Yeah.
Okay, so say, like what we say, that in earlier times, society was very good. People used to help each other. People were very supportive and all that we say, right? But this theory
Yes.
says that no, it is because we entered into a social contract. That's why we are able to live peacefully right now. Okay, but before that, what was the situation? Before we entered into a contract, what was the situation? What sort of conditions prevailed? It explains that. All right, I'll just
Okay.
explain you what it is. So they say that in a society, we entered into a contract with one another so that we are able to live peacefully in the society. But before that contract thing happened, what was the condition that prevailed in the society? That is explained by these three jurists. Okay, Thomas Hobbes says that society was very bad. It was in a condition where it was not possible to live only. It was so bad. John Locke said that it was like okay, not that bad also. It was okay. J.J. Rousseau said that no, society was very peaceful. People were very happy at that point in time. But after they entered into contract, right? After that, only our life became difficult. So three jurists giving completely three different viewpoints. Okay, so first one is Hobbes, Thomas Hobbes. So according to him, under the state of nature, as in before we entered into this social contract, men lived in a chaotic state. The situation was very bad. Men's life in the state of nature before we entered into contract was that of fear and selfishness. People were very selfish, people were not ready to help each other, and it was very bad. It was such a situation that people were not able to live there. Life was very short, and people just thought about themselves. Okay, so after that, what happens is, because all those situations prevailed, in order to get rid of those miseries that people were undergoing, they entered into a contract. Okay, and what they said is that we are going to surrender some of our rights to a single person. Okay, we will surrender some of our rights in order to make our lives better. We want to get rid of these miseries. So the law of nature can be discovered by reason, which says that a man should do or what men should do and should not do. Man has a natural desire for security and order. This can be achieved only by establishing a superior authority that must be the commanding authority. Like you can take, for example, at present times. At present times, what we are doing, we say that, okay, fine, let us have some laws. We will follow IPC, we will follow Indian Contract Act, whatsoever laws are there, we will follow it. As in, we are surrendering our rights. Why are we surrendering our rights? Because we want some sort of a security. That if I am going out tomorrow at night, nobody can kill me, nobody can hurt me, and stuff like that. Right? So, in order to get that security, I am ready to surrender my rights. That I will also not harm another person, but another person also should not harm me. Okay, so there was that sort of a contract which people entered in order to get rid of the miseries. And based on that, they tried to establish security and order. Okay, so to a superior authority, they surrendered some of their rights and they agreed to follow some obligations and give give some rights that, okay, fine, we don't need these rights, but we rather want a peaceful life in the society. So this is the first jurist, Thomas Hobbes, that life was very bad. People were very much selfish before we had this contract. In order to get rid of that situation, they entered into a contract, they surrendered some of their rights, and what they did is they gave, sacrificed on their rights just in order to maintain security and order. Okay, is it clear? Is it confusing or too much of information?
No, ma'am, not sister.
Just try to, it's like a very simple thing actually, okay? This is also a theory you will get in political science if anybody of you have that as a subject. Okay, so social contract is nothing but we entered into a contract, but why we entered into the contract and what happened when we entered into the contract, that's explained. First jurist is like society was very bad, it's because of the contract only society became livable. Okay, next one is John Locke. So what is John Locke's view? Locke's view on state of nature was completely different from what Hobbes had to say. He also interpreted natural law in a different way. So Locke was in favor of individualism, and therefore for him, natural law meant giving individuals more power than the sovereign. So Locke's state of nature was a golden age for men, but as society grew, he said that initially things were fine. Okay, initially things were fine. Initially there was no problem because there were limited number of people living in the society. And there was no as such, things were in abundance. It was not like there was scarcity or anything like that. So there was no problem as such at that point in time. People were living happily. But as number of people started growing, the concept of property came. Okay, the concept of property came, and when this concept came, people became insecure about their properties. All right, and it was for the purpose of protecting their property that men entered into a contract, which is again nothing but social contract. Just because this concept of property came, in order to protect our securities, we had to enter into a contract. Under this contract, he did not surrender all his rights, but only part of them. Whatever was needed, only those rights were surrendered, not everything. All these rights were surrendered in order to again maintain order and to enforce law of nature. The natural rights like right to liberty, property, and life were to be retained by men. So we did not surrender right to liberty, right to property or life, but some rights were surrendered so that we can maintain order in the society. Locke's support to individual liberty. Locke stood for individual liberty and advocated that the power of sovereign is not unlimited because we have not surrendered everything to the sovereign, but rather we have surrendered some of our rights to the sovereign. His power is not unlimited. According to Locke, individual has a right to protest against the sovereign if he is unable to protect rights of the individual. Individuals also have a right to overthrow the existing government as well, in case existing government is not able to provide them that security, protect their rights. According to him, individuals' right to liberty, property, and right to life are the basic natural rights, and the sovereign must realize these rights and take a decision, taking into consideration that his decision is not affecting or in any way taking away these rights from the people. Okay, so John Locke said that society was initially very good, people were very happy, but just because number of people increased and the concept of property evolved, we required a law to protect it because insecurities were also developing at that point in time. And while entering into the contract, we surrendered only some of our rights. Some basic rights we retained with us, like right to liberty, property, life, etc. we retained. And sovereign's main function was that he had to ensure that peace and order remains, our rights are protected. In case he is not able to do that, we can overthrow the existing government as well. Okay, is it clear?
Yes.
Third one is J.J. Russo. So what is Russo's viewpoint? He said that natural law and social contract received a new interpretation. He gave a new interpretation to it. And for him, a social contract is a hypothetical construction of reason. Before social contract, men lived a very happy life and there was equality amongst men also. So men entered into a contract in order to preserve the rights of equality and freedom. They surrendered their rights not to a single individual but to the community as a whole, which Rousseau called as general will. So all the people came together and they decided that, okay, fine, peace and harmony prevails in our society, but let's make sure that this equality and freedom prevails forever. So that is the reason why they entered into the contract. And this contract was in the community, not like an individual person surrendering his rights to the sovereign. Okay, so it is called as general will. All the people wanted to ensure protection or preservation of equality and freedom. So they entered into the contract. Okay, so we entered into the contract for preserving this right to equality and freedom. And this contract was in the community, not like one person surrendering his rights to the sovereign. Theory of general will. So, according to J.J. Rousseau, it is duty of an individual to obey the general will, because in that way he is obeying his own will. Because all of them came together, all of them decided that let's surrender these rights, let's do these things. So it's nothing but following his own will. Whatever he agreed to do, he is doing that only. And by doing it, he is fulfilling general will because everybody agreed to the same thing. The government and the laws made must conform itself with the general will. Whatever they agreed, in that terms only laws can be framed. So yes, laws were there, but then those laws were framed in that terms only. Whatever people agreed to satisfy that, laws were there. And if they are not able to, so that general will, and if they are not able to, so that they could be overthrown. In brief, Rousseau stood for the interest of the community rather than interest of individual. His natural law theory stood for equality and freedom of men. So in order to preserve that equality and freedom of men, people came together and they decided what should be done. Right? It is nothing but general will. They entered into a contract with themselves and they agreed that let's surrender on these things or let's follow these certain things. And that became applicable. We had to follow that only.
Social contract differ from each other, no ma'am? Tom's social contract was different,
Yes.
John was different, and JJ was
Yes.
different, right?
All three philosophers gave their own viewpoints on how the social contract came or what was its impact. But the idea is same only, that there was a contract. But how the contract came and what was its impact on the society, there they differ in their viewpoint.
But contract also differ, right?
Yeah, but all of them agreed that yes, there was a contract. How the contract came, what was its impact, there they differ.
Okay.
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 So social contract theory, there are three jurists, three philosophers. First one said that men's life was very bad in the primitive society. They were selfish and brutal. So they had to enter into a contract. After that, life became okay. John Locke said that initially life was very good. People were living very happily. But number of people increased and the concept of property came. As the concept of property came, our insecurities also increased. In order to protect our insecurities, people entered into a contract. But they did not surrender all of their rights. Only some of their rights were surrendered to the sovereign. They even retained the right of overthrowing the government in case the government or sovereign was not able to protect their interest. But J.J. Rousseau says that So J.J. Russo says that It is like a hypothetical situation. Before contract, men lived a happy life and there was equality also. But they entered into a contract to surrender their rights, not to one single person, not like surrendering it to the sovereign or something, but like a community. They came together and they decided what should be done, what should not be done, and they started following that only.
Okay.
Okay, then talking about the modern times, in the 19th century, we saw decline in natural law theories. Okay, so the problems created by new changes and developments demanded political
Ma'am?
yeah, so it demanded certain changes, okay, in order to solve those problems which were existing. Modern sciences and political theories started pitching that there is no absolute and unchangeable principles. As such, we don't have something called as like natural law which should apply forever. Many historians rejected the social contract theory by saying that it's just a myth. It's not like there was a contract or something like that. That sort of a thing does not exist. All the factors led to a gradual decline in natural law theories during the 19th century. But then again, we saw revival of this theory in the 20th century. It was because of it emerged as a reaction against the legal theories which had exaggerated the importance of positive law. Positive law was given too much of importance, that for every single thing we should have a written code, we should have a written law. So that much of importance should not be given to positive law. That's how again natural law gained some importance. It was realized that abstract thinking was not completely futile. It's not that when we say that okay, law has originated from our inherent ability to differentiate between right and wrong, it's something which is not like completely futile. It's having some importance in reality. That was also being realized. Positivist theories failed to solve problems created by the changed social conditions. So even though we had legislations,
Ma'am, I have a doubt, ma'am.
yeah,
Ma'am, so constitution is basically codified laws, right?
yes, codified.
So is the UK more towards the natural law school because they are more into the precedents and all?
Not like natural law as such, but you can say it is based on the principles of equity, justice, and good conscience. That what is right, that should be done. What is just in a certain given situation, that should be done. And based on that, judges are given much importance that you need to see in a given situation what is right. Based on that, you need to give a decision rather than just like a robot following whatever is written in a code, and just like doing maths, you apply a formula in a certain given problem, right? So law is not like that, that you would apply a formula and you would get an answer, but rather you need to apply your mind and see whether it is providing justice or not. So we can't say as such natural law, but yes, based on the principles of equity, justice, and good conscience, we can say.
Okay, ma'am.
Ma'am, even India law containing a constitution, we tend to like change the this thing judgment in base of circumstances, no ma'am?
Yes, yes, that is possible because we say that even though we have written laws, right? Even though we have legislations, we say that legislations are given by parliament and state legislature, right? So they give it in a skeleton form, as in they give the basic framework of it, all right? Because they will be sitting at the parliament, just they would think about a situation and they would frame a law, right? They don't have that much of practical exposure. So when a law is framed, the members of parliament can only think about a situation and try to address it by way of making a law. So laws are in a skeleton form when it is passed from legislature. But after that law starts to apply in the society, courts try to apply it. Too many cases are filed before court, and there are practical problems that judges go through, and judges see that okay, this is might be a problem, this certain thing is missing, this certain thing needs interpretation. So at a later point, judges put flesh and blood in that legislation. Okay, so from
Ma'am, then
legislature,
to
yeah.
what extent can changes be brought under the constitution?
Sorry,
Then to what extent can changes be brought under the constitution, ma'am?
to what extent constitution can be changed?
Yes, ma'am.
Okay, so constitution, you can change any part of constitution. There were like cases also. First, it was like, can you change the preamble or not? Later on, it was said like there was Ray Berubari case wherein it was said that no, you cannot change the preamble, but other parts you can change under Article 368. But then there was Keswananda Bharti case which explained it that you can change any part of constitution. You can change fundamental rights also, directive principles also, preamble also. You can even change the amending powers mentioned under constitution. But just one thing is that you cannot change the basic structure of how our Indian constitution is. So if we say constitution is supreme in India, all other laws derive its validity from constitution. Tomorrow you cannot make an amendment and say that no, from today constitution is not supreme, rather IPC will be supreme. That you cannot do. So it's to an extent wherein you are not changing basic structure or basic framework of Indian constitution. If today we have a democratic form of government, tomorrow you cannot say that we will have dictatorship, let's change it. That you cannot do because it's like a basic structure.
Okay, ma'am.
Okay.
All right. So this, even though we were having lot many legislations, there were certain problems in the society which these legislations were not able to address. We had too many legislations, but then problems were also there. Okay, problems were also there. Then during the two world wars, the world witnessed a great destruction of human lives and property, and principles of natural law were approached in order to attain peace. So that time also we saw that it is about what is right and what is wrong. It's about doing right from your own self. It's not like written laws you have means everything would be all right. That is not true. So that is how it was again realized. Okay, so talking about natural law, it is also known as philosophical school because this entire concept is very much philosophical. If you compare it with positive law, which says that yes, legislature is there, they will make laws that would be applied. So natural law, we divide it in 4 different time frames. First is ancient theories, medieval theories, Renaissance, and modern theories. Okay, so I will try to prepare like a chart for this one so that it becomes a little bit easier for you. But yeah, schools are something which is little bit too much of information that, like you need to study only. But I can try to prepare a chart so that it becomes a little simplified for you. Okay, is it clear?
Yes, ma'am.
Yes, ma'am.